Good morning. Oh, I know these two individuals. Charlie, would you give Monica and Mark those black folders? Charlie? Yeah, thank you.
And this is your microphone that goes to the live stream on YouTube.
Okay. Do I need to stay here?
Well, the closer you're to this, the better the sound's going to be.
Okay, all right.
Yeah.
Hi, Phil. So, good morning. Welcome to the ABCs of Criminal Law, otherwise known as Law School 101 Criminal Law. My name's Colette Wallace McEachin. I'm the elected Commonwealth's attorney for the city of Richmond. With me presenting is Deputy Commonwealth's Attorney Kelly Burnett. Kelly is in charge of our Community Justice Reform Unit, which I created when I was elected. And as part of her supervision of that unit, she and I developed this ABCs of Criminal Law because it's clear to us, given the past 4 or 5 years in Richmond, right, from COVID and those effects to the murder of George Floyd, to the riots and protests, to other protests that happen sometimes at the Capitol because Richmond is the capital, and so when the legislature is in session, there are sometimes protests. And then, of course, given the new federal administration, I assume that there will be many, many protests. So I wanted people to understand their rights and responsibilities in the criminal justice system. And the only way you can know that is if you know the ABCs of criminal law. So that's what we're going to do this morning. It's going to last, it's 10:35 now. This will last approximately until noon. And so I'm thinking that Kelly and I will talk for about an hour off and on, but not lecture. So if you have a question, raise your hand and we'll, recognize you so that we can address the questions as we go. Restrooms are outside and to the right of this room. And does anybody who's here have any questions? All right, we'll get started. So if you look in your black folders and open them up, on the left-hand side, you'll see a green and white sheet. And this will be referred to later, but just want to make sure that you have this green and white sheet. And then you also have a copy of the Bill of Rights. Oh, there we go. Because as we all know, people are forever saying, oh, I have a constitutional right to do this, that, or the other thing. And sometimes you do, and sometimes you actually don't. You just wish you had that right. So these are the Bill of Rights, and as we all know, these were the amendments to the Constitution of the United States, the first 10 amendments. And then finally, the third piece of paper on the left-hand side of your folder are 2 hypotheticals. So every profession and every industry has their own buzzwords, right? There are things teachers say, engineers say, doctors say, that unless you're in that profession or industry, you don't know. Plumbers, electricians, the whole thing. One of the buzzwords you learn in law school is hypothetical. Professors and teachers give you hypotheticals, and all a hypothetical is a scenario. It's a story. Let's pretend this is the factual scenario. How do we apply the law to those facts? And so that's what a hypothetical is in law school. For the purposes of this morning, Kelly and I created 2 hypotheticals. And in thinking about how to design this course, I wanted to include a hypothetical that was violent and then one that included a non-violent scenario. So everybody here is educated. I won't read it out loud, but I will read it for the purposes of this video. But if you all would read it to yourselves while I'm reading out loud. The first hypothetical, Michael is a 25-year-old man who's been living at home with his parents since he developed mental health issues while attending college. Michael is a loving son when he takes his medications and attends therapy. Recently, he's decided that pharmaceuticals are dangerous, and he will deal with his health issues through herbal medicines, diet, and exercise. He told his parents that he purchased a 9mm handgun because he sometimes takes walks at night and, quote, it could be dangerous, so I just want to be safe. Michael has a mental health crisis at home and starts screaming at his parents and threatening to kill himself. A concerned neighbor hears the noise and comes over to help his parents calm Michael down. Michael sees the neighbor walking in the yard and shoots the neighbor. Michael's parents call the police and Michael is arrested. Luckily, the neighbor survives being shot. So that's the first violent hypothetical. The second non-violent hypothetical, Hannah has always been good at fixing things. She's finally saved enough money to buy a truck and tools needed to start Hannah's handy repair service. She leaves her truck unlocked while she's going back and forth unloading her equipment at a job site. Jacob has been watching this for a few minutes and he steals her truck the next time she's out of sight. Hannah's devastated because she's lost her truck, her tools and equipment, and therefore she's unable to make enough money to pay her rent. A few days later, Jacob is arrested after running a red light while driving Hannah's truck. The truck is trashed and $1,500 of tools and equipment is gone. So these are both very real scenarios that Kelly and I, in our joint 50 years of experience at the Richmond Commonwealth Attorney's Office, have seen in court. So this is not unusual at all. So that's what's on the left-hand side of your folder. And then on the right-hand side is the PowerPoint in the usual format so that you can take notes as we go through the PowerPoint. Anybody have any questions at this point? Okay, everybody's got something to write with? Okay. All right, let's start school.
So be thinking about the hypotheticals as we go through the presentation, and then we'll talk about them at the end.
Okay. Oh, I would also like to note for those of you who, this is being videotaped, and so I just want to put that out there. I don't think anybody this is not looking at the audience, it's just at me, okay? So for those of you who are concerned about whether or not your face is going to be seen on some YouTube channel, it will not because of this. Maybe because of what you all posted on YouTube, but not because of this. Okay, so what's criminal law? Why are we here? Criminal law involves laws that define criminal offenses and regulate the apprehension, charging, and trial of suspected persons. The point of criminal law is to ensure public safety and order. And I know sometimes we have different emotions depending on who is imposing that public safety and what that order is supposed to be. But generally, the point of the Commonwealth Attorney's Office and the point of law enforcement is for people to feel safe, for people to feel safe on the streets, at work, at school, at their job, at public places. It's so that people can feel safe. And when someone decides to violate that public safety of the community, that's when the criminal laws come into effect. Criminal laws don't have anything to do with custody, visitation, civil landlord-tenant disputes, contract disputes, whether there's a pothole in the streets, whether the lights come on at the right time. That is not criminal law, that's civil law, and we're not going to be discussing that. So my office is responsible for enforcing the criminal laws, and I will tell you all that the Richmond Commonwealth Attorney's Office has about 40 attorneys who I supervise through my deputies like Kelly, 20 paralegals, and then 10 victim witness advocates, and there'll be a page about victim witness advocates. So we have roughly 70 people in our office. We're in the main courthouse downtown, the John Marshall Courthouse across from City Hall, and then there's a courthouse at 10th and Hull on South Side, and then the Juvenile Domestic Relations Courthouse, which Kelly used to supervise, is up in Church Hill in the East End. So one of the good things, I have varying emotions and feelings about social media and the internet and things like that, but one of the good things is it makes information generally easy to find. And so if you ever want to know what an actual law says, not what the paper says it says, not what a legislator says it says, not what TikTok says it says. If you want to actually know for yourself, you can Google LIS, and that's the Legislative Information Service. So that was set up by the General Assembly, and it lists every single law in the Commonwealth of Virginia. The sheet that you have, the green and white sheet, tells you that you can access the Code of Virginia, which is all of the laws, the Virginia Administrative Code, which regulates agencies and the protocols within those agencies that are not laws, but that are agency rules, and then also the Constitution of Virginia, by which we are governed, as we are governed by the Constitution of the United States. All of that is accessible on this website. Kelly, anything?
Okay. We mainly, in our jobs, use the Code of Virginia, and we're going to talk specifically about those statutes that we look at. But the Constitution governs all of our practices. It's just that the code is what we use in our day-to-day for charging and for prosecution.
So when you hear code, just think of law or statute. That's all the code is. So the code sections that the Commonwealth Attorney's Office and that criminal law practitioners use the most are these 4 codes by number. 16.1 is all the code for the general district courts, including the adult general district courts and the juvenile and domestic relations courts. That's 16.1. If you Google LIS, Code of Virginia, and you type in 17.1, you will get all of the laws regarding the circuit courts of Virginia. And then the same thing for 18.2, that lists all of the crime and offenses: assault of a student, assault of a teacher, assault by a law enforcement officer, shooting, stabbing, petty larceny, embezzlement. Every possible criminal offense that you could think of is in 18.2, and then dash, and then there'll be a number after that for each individual law. And then 19.2 governs criminal procedure, what attorneys do in court, what we have to be aware of when we're actually gathering evidence, presenting it in trial, that type of thing, what things that govern juries. So those are the laws, the actual numerical laws.
You know, I just realized we didn't include traffic.
So
that's another one.
46.2, yeah.
46.2 is all the traffic laws.
Can you tell us what's the difference, or how do you decide what goes to district court versus circuit court?
Good question. Yes. So the district court has, general district court has jurisdiction over misdemeanors, which is, we're gonna talk a little bit more about the penalty structure, but they have jurisdiction over misdemeanors and then preliminary hearings for felony offenses. And then circuit court is our felony court. And so we also have the ability to directly indict cases to the circuit court that are the more serious cases, the felonies, and those are generally punishable by more than a year. The juvenile and domestic relations court has jurisdiction over any crime that involves a juvenile, so whether that juvenile is the victim of the crime or the accused in the crime, and then cases involving family or household members. So if you have, it's defined in the code, certain blood relations, and then also if you're living together as family members.
And if the crime involves juvenile and an adult, how will that happen?
So it depends. If they are, let's say a juvenile and an adult are co-defendants, but the victim of that crime is an adult, then the case with the juvenile accused will go to juvenile court, and the case with the adult accused will go to the adult court. In those scenarios, sometimes we will ask one of the courts to cross-designate the case so that they can be heard together for efficiency. And so the general district judges and the juvenile judges have that ability to cross-designate each other to hear cases.
Okay. So going on to the next slide. First appearance, are we at first appearance in court? Oh. Yep, first appearance in court. Okay, so you've been arrested. So Michael got arrested in hypothetical number 1. And so what's going to happen to Michael and what's going to happen to Jacob based on these hypotheticals? One of the things that's so important for people to realize, and what a lot of people don't know, is that lawyers and judges can't make stuff up. Like, there actually are rules of evidence and laws and procedures that we have to follow. Otherwise, our license would be suspended or revoked. If you're a judge, you could be removed from your position. If you're a police officer, you could have your powers of arrest and gun removed, and you could be eventually not able to get a job as a police officer. And so I want people to understand that regardless of the social media noise that is sometimes out there, there actually are rules and laws and code sections that govern what happens to people. And you all can find those out. You can know that. It's not a secret, and the law shouldn't be a secret. And that's what my office wants to put out there. So Michael and Jacob both got arrested. Michael for shooting someone, Jacob for stealing Hannah's truck and her equipment. They each have to be arraigned within 72 hours. And all arraignment means is they have to be brought before a judge. They can't be held in jail for 6 weeks, 6 months, 6 days, and not see a judge. In Virginia, it is the law that you have to be arraigned and brought before court within 72 hours of arrest. And it's 72 hours because if you're arrested on a Friday and you're not released from jail, basically not released from jail, then that Saturday, Sunday, and Monday, if it's a holiday, is the 72 hours. So as soon as court opens, after you're arrested, you have to be brought before a judge. The arraignment process, well, before the arraignment process, once the officer arrests you, the officer doesn't get to decide what charges to put on you. So Michael was called, the police were called to deal with Michael's situation, and Jacob was arrested while he was driving the truck. But the officer still has to go before a magistrate, which is a separate individual who is not connected with my office, is not connected with the police department, is not connected with the courts. The magistrate then decides based on what the police officer says and what, if anything, the defendant wants to say about what the police officer is alleging. And then the magistrate makes a decision over whether or not there is probable cause to issue a charge and what that charge should be. The police do not get to decide that. I don't get to decide that. The magistrate does that independently. And the magistrate's office is in the Richmond Justice Center, the Richmond City Jail. But they are not associated with the jail. Yeah, sure.
So, in the case where the magistrate issues warrants and the warrants are served, and the person doesn't get arrested, how does that work? If the warrants are served, police comes to the house, but the person doesn't get arrested. Is that normal?
That usually does not happen. Usually if there's a warrant, you're going to get arrested. You're at least going to be brought before the magistrate, and the magistrate at that time may make another determination as to whether or not you should receive bail and be released on bail.
Yeah, because in my case, that person was not arrested.
Okay.
Occasionally, there is something called a releasable warrant. And so the magistrate will make a decision when issuing the warrant, if the accused is not present, that when the officer serves that warrant, that they don't have to be taken into custody. So that's called a releasable warrant. And then also the officers sometimes will issue a summons. So the most common incidence of that is a traffic offense. And so that is a different paper that does not require them to go to the magistrate because they're not taking the person into custody. They're just saying, this is what you're cited with, and here is when you need to appear in court. And then it's usually like a week or two later, they'll come to court.
Okay.
But that would, neither of those scenarios would happen in our hypotheticals because they're more serious crimes. Yeah.
Okay, so Jacob or Michael is appearing before the court. The judge is going to read the charge to them, what the language of the charge is and the code section. So you're hereby charged by the Commonwealth under 18.2-57 for assault. Theoretically, that would be what the court would say. You have the right to an attorney. Can you afford to hire an attorney, or do you want the court to appoint attorney for you? You can always hire your own attorney at your expense. If you cannot afford an attorney, the public defender's office exists and they will represent you. But ultimately, if you are convicted, you will have to pay some part of that back. So no attorney is free unless they are actually doing it pro bono for you, right? The retained attorney is going to want some money, and the public defender's office, eventually you will basically fill out an invoice to the Supreme Court, or they will fill out an invoice saying, I represented Joanne, I represented Michael or Jacob for 100 hours, and I need to be paid. And then the Supreme Court, using your tax dollars, will pay them. The judge will make an initial bail determination. The only two, Virginia law says that the only two considerations that a judge should make in determining whether or not someone should be released on bail is whether they are going to appear in court in the future for their trial or their hearing, or whether they're a danger to the community. That's it. There used to be a much longer list of things that a judge could consider, but the General Assembly got rid of that. And so these now are the only considerations. Will the person come back to court? If they are out, if I release you, are you a danger to yourself or the community? If you, yeah, sure. Mr. Taylor, can I, since you are in fact a private criminal defense attorney who has invoiced the court, would you please explain?
Yes, ma'am. We receive our compensation, as she said, and I say we, defense attorneys who are appointed to a case, we receive our compensation once we fill out this form called DC-40. The client doesn't see that form. The court sees that form and has to approve it. If I put in 100 hours, check. Trust me, they check it every single thing. There's someone in the clerk's office, for example, check and make sure that I've crossed my I's to cross the T's,
dotted your I's.
And we do get paid through the Virginia Supreme Court eventually, okay? After it goes through the clerk's office, it goes to the Supreme Court. What she's talking about is when the client serves his time, he's going to have a bill. That bill is part of the compensation that went to the attorney that was court appointed. So everybody thinks in the public that court appointed means free, but as she's pointed out, it's not entirely free. That is a bill you eventually have to pay. Now, no one expects you to pay while you're in jail or in prison. Once you get out, that bill follows you until it's paid. It's not a whole lot. It's not as much as the attorney was paid, but you do get a bill.
Does that help?
Yeah, I'm just a layperson, and that just
Yeah.
my mind.
Oh, good. We've only been talking for 20 minutes and I've blown somebody's mind. And this is working. This is working. This is working, right? Because the point of this is for you all to have this information and then tell whoever did you know this? I just learned this, and spread the information. So,
I have a question.
oh,
So
Mark.
I'm clear on the the role of the judge and the magistrate, I don't understand how that works sequentially. So within 72 hours, the arraignment has to happen.
Up by the judge. The magistrate has already seen the person, which is how they ended up in front of the judge. Yes, yes. So arrest, magistrate, judge.
Magistrates work 24 hours a day, 7 days a week, so there's always one on duty. And so the person is taken immediately to the magistrate if they are held by the police. If the police arrest them and take them into custody, they go to the magistrate immediately. And then the 72 hours starts from the time that they're taken into custody.
Okay. So I'm still in front of the judge, and Michael and Jacob, like most people, of course, don't want to be in jail while they're awaiting trial. They want to be able to go back home, do whatever. So the judge has looked at Michael's situation, and if you were the judge, raise your hand if, given the hypothetical, given the facts that you have, you would release Michael back to his parents. Raise your hand if you would release Michael back to his parents. Okay. Raise your hand if you would release Jacob. Anybody here would release Jacob for stealing the car, trashing the car, stealing the equipment? 2, 3, 4, okay, 5, okay, all right. Why would you release, I know you. Why would you release Jacob?
I would release Jacob only because I feel like it hasn't been proven yet. Yes, he was driving the car. Yes, she's saying that he stole the equipment, but I don't think it's been proven yet, and it's a minor offense. I'm using that term like that.
Because it's not your truck and it's not your equipment, right? Right. Okay. All right. And everybody agrees, I guess, given the fact that Michael allegedly shot someone, right? Because he is also innocent until proven guilty. Everyone is innocent until proven guilty, but you have to be. So does that make the difference? Yeah. Okay. All right. Okay. Very good. All right. So those are the things that the court would think about, and so during the arraignment, Michael and Jacob would probably have had a public defender appointed at that point. And so the public defender and the Commonwealth, either then or at a hearing a few days later, would talk about whether or not Michael or Jacob should be admitted to bail. And these are the different conditions of bail. So you pay a bond to get out on bail. A lot of people throw both of those words around. You pay a bond to get out on bail. My office for at least 10 years, if not longer, has supports the policy that we do not ask for a cash bail. We do not try to penalize people who don't have ready access to money by saying, oh, well, if you could come up with $1,500, you could get out, but you can't, so you're gonna stay in jail. So the only two things that the Commonwealth Attorney's Office in Richmond cares about are those two statutory conditions. Are you a danger to the community? Are you gonna come back to court? And we look at, your criminal history and the facts of the case, all the things that you all would look at. And we make a recommendation to the court. And then Jacob and Michael's public defender or their retained attorney, if they decide to hire Mr. Taylor, would make that recommendation at a bond hearing, a hearing to decide whether or not you should be released. And the court would ultimately make the decision. So the court doesn't always agree with the Commonwealth, and the court doesn't always agree with defense counsel. The court makes its own independent decision. As part of the terms of your admission to bail, if you are admitted, if the court says, all right, you can be released, you're not a danger to the community, I think you're gonna come back to court. While you're out, you need to keep the peace and be a good behavior. Don't commit any other crimes while you're out. I may place you on a home electronic monitoring or a GPS anklet around your ankle so that we know where you're going if I want to make sure that you are not going back to the young woman's house who you're stalking, right? I may order you, Michael, Jacob, to go to pretrial services that are offered by the city of Richmond, where you would have a meeting with a pretrial officer. You might have drug and alcohol screens. There's something called a scram bracelet, which can be put on someone who has a DUI, and it monitors the amount of blood alcohol in your body. You'll get a court reminder, and another condition may be that you have no contact with the victim. Obviously, in a stalking case, a lot of domestic violence cases, sometimes it's neighbor against neighbor. Okay, I'm gonna let you go back home, but because the neighbor's cat keeps going in your yard and digging up your garden, you can't go over there while this case between the two of you is pending. Okay? Any questions about bail or bond? Kelly, you want to take the next one?
Okay. Victim Services is a department under the Commonwealth's Attorney's Office, and they provide assistance to all victims of violent crimes. And that includes victims whose cases are not currently charged or being prosecuted. So let's say you are a victim of a crime, but the police have not solved that crime. They do not know who stole your car or who damaged your mailbox. Well, that's not a good example because that's property crime. Let's say you're assaulted by a stranger and they haven't solved that crime, right? You are a victim of violent crime even though your case is not currently being prosecuted. And so Victim Witness Services is available to assist you. If your case is being prosecuted, they will walk you through that court process. Their job is to notify victims of court hearings, to answer questions that they have about the hearings, to make sure that that contact information is current. They assist the attorneys in making sure that victims know when to be at court, what they can bring with them, all the details of going through the court process. So they navigate that for people. They also help provide transportation to and from court. Our community justice unit has a program where we use Uber to help people with transportation, and then we also have funds to help with parking because we're trying to eliminate barriers to participation in the justice process. That's one of our main goals for both survivors or victims and then also people who are accused. We want everyone to have access to justice and to remove those barriers. They also have connections to support services, therapy, groups. They're in touch with all of those resources. They have a homicide support group for people who have been family members of those who have lost their lives to a crime. And they also assist with the Virginia Victims Fund. The Virginia Victims Fund is a state fund that helps with three things in particular. If you are a family member of a victim of a homicide, they will help with funeral costs. If you have medical expenses because you are a victim of a crime, they assist with that. And then also for sexual assault cases, they will pay for the forensic examination by a qualified forensic nurse at a hospital. Our Victim Services has provided some goodie bags that they would love for you to take home, and so those are at the back, and you're welcome to grab one on your way out, and they also have some resources back there that you're welcome to take.
Any questions about Victim Services, bail or bond? Okay, so and just applying what Kelly had said, so Victim Witness Services would get in touch with the neighbor and help the neighbor through the process the way Kelly said, right? The neighbor's been shot by Michael, Victim Witness Services would let the neighbor know when the next hearing is, what's going on, where Michael is. Michael going to be back at the house next door? Has he been released on bail? So Victim Witness Services would let the victim know exactly what's going on. Unfortunately, with Hannah, because her crime is, what was it? Only a minor crime. Only a minor crime. It's only a property crime, right? And so Victim Witness Services is not able to afford to provide services to victims who have suffered property crimes or fraud crimes, things like that. You have to be, it has to be a personal injury.
Yes. Yeah. Not to say that we don't do what we can to help those victims through the process, but it's typically, working directly with the prosecutors to get that information.
Well, normally the prosecutors would try to make sure that the victim is compensated for the property crimes. The defendant has to pay restitution.
Right.
Exactly.
Yep, getting there. Yep. Okay, so role of defense attorney. Very, very well said, Mr. Taylor. So, as we all know from the Miranda warnings that we've heard the police say on many, many TV shows, if you cannot afford an attorney will be appointed for you. That's the public defender's office. The public defender's office was set up by the General Assembly. It was a statutory creation, and there are roughly 120 different counties and cities in the Commonwealth, right? Richmond, Henrico, Chesterfield, Botetourt, Wise, Lunenburg. There are only 25 public defender's offices. So in most places, people are represented by private criminal defense attorneys because there is not a public defender's office that has been set up for their city or county. Once you have, the role of a defense attorney is to be a zealous advocate for Michael, a zealous advocate for Jacob. Unlike the Commonwealth Attorney's Office, where prosecutors have an ethical duty to promote justice and we do not have a duty to represent the neighbor. The neighbor is not our client. Hannah is not our client. Neither one of them can say, I want you to do this. We represent the entire state of Virginia. And for our locality, I represent all of the city of Richmond. And so I can't just look at what Michael wants or what Jacob wants, but that's what their criminal defense attorney is supposed to do. Focus like a laser on zealously representing them. So we have different responsibilities, and ours is much broader than that of a public defender or of a criminal defense attorney, although obviously we all want justice, right? Ultimately, we all want justice. Defense attorneys' conversations with their clients are confidential. We can't talk with the client. We can't talk with Michael. We can't talk with Jacob. If they are represented by an attorney, all of our conversations, all prosecutors' conversations are with that defense attorney, right? Because otherwise there'd be an imbalance of power. Defense attorneys do have a duty to present to their client all of the offers that a prosecutor makes. So if in Hypo 2, I've spoken with Hannah. She's shown me the receipts that show that she actually bought $1,500 worth of equipment. She happened to take a picture of her truck because she was so proud of it, and I can see the equipment in there, so I know that she's not, making something up. She had filed a stolen car report with the police, right? So there's evidence that what she says happened. But it's a nonviolent offense. And Jacob maybe doesn't have a prior record, or Jacob has something else going on, mental health issue, substance abuse issue, then what I might say to Hannah is, I'm going to make an offer to reduce this grand larceny auto theft charge and this felony theft charge of your equipment to 2 misdemeanors. And that's the offer I'm going to make. And if she is okay with that, then I would give that to the defense counsel. And the defense counsel has a duty to let their client know, hey, right now you are looking at 2 felonies. The Commonwealth is willing to reduce each of those felonies to a misdemeanor, and we'll talk about the time, but you won't have a felony conviction. Your record will still be clear of felonies. Do you want to do that? Defense attorneys have a duty to communicate with their clients. Ultimately, however, the client makes the decision. And so most criminal cases in the city of Richmond and throughout the country are settled by plea agreements, because each side recognizes that neither one of them has a perfect case. And if it goes to a jury or if it goes to a judge, you could lose. Hannah doesn't get anything, Michael doesn't get anything, Jacob, right? So 95% of most criminal cases are resolved through a plea agreement, and the attorneys have a duty to tell both of their parties what that plea agreement is. And if it's Michael, if it's Jacob, if it's in the city of Richmond, if it's a felony, if it's in circuit court, that plea agreement is going to be written out. It's going to say, these were the charges. These were the original charges. You're now pleading to this. Therefore, your sentence will be this, and your other conditions of this plea agreement will be this. You have to sign it. And then it's read aloud to you, or big parts of it are read aloud to you in open court by the judge. Mr. Michael, are you satisfied with the representations of your attorney? Are you satisfied with his or her services? Is this your handwriting? Is this your signature at the bottom of this plea agreement? Have you gone over this plea agreement with your attorney? I'm going to read this plea agreement to you. Do you agree that this is your plea agreement? So it's never a situation where, I won't say never, but it is highly unusual that someone enters into a plea agreement and they're unrepresented if it's a felony. They haven't received a written copy of the plea agreement, and the plea agreement doesn't have their signature on it. Yes. Okay.
So this is just a kind of prosecuting attorney, is that the same as a?
Commonwealth attorney, yes, yeah.
And who writes the plea agreement? Would that be the
Commonwealth's attorney, right.
And what happens if they fail to write the plea agreement or just slips through the cracks?
So it would never slip through the cracks. What would happen is, in Richmond, so every jurisdiction is different. So that's number one. In Richmond, if the charge is a felony and therefore it's in circuit court, the plea agreement has to be in writing. If it's in general district court or juvenile domestic and relations court, if it's in those courts, the plea agreement does not have to be in writing. So it may depend on what court you're in as to whether or not there's a written plea agreement. Next. You want to take this one? This is your bailiwick.
Sure. So the traditional path through the criminal justice system would involve a trial and then a sentencing after someone is charged. However, as Colette mentioned, most of our cases are resolved by some type of agreement. And we try as much as we can to provide alternatives to trial and to incarceration. So we recognize that although incarceration is a necessity for the safety of the community in some cases, that it also causes harm. It causes harm to people who are incarcerated, it causes harm to their families, and that is something that if we can protect the public safety and avoid that harm, we want to be able to do that. It's also important, as much as we can, to identify the root cause of why someone is committing a crime. Because if we don't identify the root cause, then they are very likely to just repeat offense, right? We see that a lot. People who are dealing with especially mental health issues and substance use disorder, it's kind of like a revolving door. We see them, they get some kind of punishment, they're out for a while, and then they come back to court. So we try to address that by identifying those needs and then providing alternatives. So one of the things that we do is if there is, this is typically in a minor case, if someone doesn't have a record, if this is out of the norm and they come before us on a minor offense, we will generally continue their case and give them something like community service, just to let them show that they are law-abiding for a period of time and they have some kind of consequence for their behavior, and then we will agree to dismiss the case. We can do this either informally by just putting the case off and having an agreement with the defendant, or we can do it formally by asking the judge to make a finding of fact that the evidence is sufficient for them to be guilty, and then giving them time to complete whatever conditions we've agreed upon. And then they come back to court at the end of that period of time and their case is dismissed. And we call that either taking a case under advisement or deferred disposition. So we also recognize that not everyone deserves to have a criminal record, and that a criminal record can also be harmful. There are collateral consequences to that, such as affecting employment, housing, public funds. So we don't want to make the consequences more than the conduct deserves. And sometimes a conviction will do that. So one of the things that we might ask the person to do would be pay restitution. So in Hannah's case, if we might agree to take that case under advisement and then either reduce it or dismiss it if he pays restitution and does some other things, depending on his particular circumstances. We recognize that felonies have bigger collateral consequences than misdemeanors, and so we are particularly conscious of if someone doesn't deserve a felony conviction, we try to avoid that.
I'm sorry about it. Is
No,
there
no.
a time frame or a time limit on restitution being paid back to the person?
So the court is required to set a deadline on the restitution, but then if the person hasn't paid by that time, they have an opportunity to come back to court and explain why they may not have been able to pay. And then it's up to the judge to decide whether or not they give them more time or they give them something like jail time for not paying the money. Does that answer your question? Yeah. Yes.
I mean, statement. Case in point, you said you try to find out what caused the people to commit the crime. Well, a little bit by myself, I'm a mentor for a lot of youth in the hood, and a lot of problem that I see in the hood is poverty. And what happened is that I have 4 of my boys right now, 3 of them got 8th grade on, and one of them in the same family, they got caught out here at Short Pump, and it was stealing. And rather than take them to court with that 8th grade, but I did not beat it nothing 13 times. You know what I'm saying? They ain't steal nothing no more. Case in point, you have to find out exactly what's happening in the community. You get on the ground and find out exactly what these kids are going through. These kids are going through some big problems in the hood. So I said it to you, remind myself, we have to go back to the root of the problem. The problem is poverty.
Yes, I agree. Thank you for sharing.
Let me just also say that we've been talking about misdemeanors and felonies, but we haven't defined it yet. Actually, we put it at the end instead, should be here.
Probably.
So a misdemeanor is a criminal offense for which you can be punished by no more than 12 months in jail. A misdemeanor is a criminal offense, and the maximum punishment is 12 months in jail and or $2,500 fine. That's a misdemeanor. And lots of things fall into misdemeanors. Petty larceny, misdemeanor property damage under $1,000, some bad checks. What else? What are the usual? Those are a lot of the usuals. Destruction of property,
Yes.
right? Right. What elevates a felony is a criminal offense for which the penalty is 1 year in prison up to life in prison. 1 year in prison up to life in prison. So misdemeanors, if you get misdemeanor time, are served in your local jail, in the Richmond Justice Center. If you get felony time and you have to serve felony time as opposed to that time being suspended, you may serve some of it in the jail and you may be transferred to a Department of Corrections state facility, DOC, and serve it in a state facility, what used to be called a penitentiary. So that's the difference between misdemeanor time, 12 months, felony time, 1 year to life.
And for sake of time, I'm not going to go into a lot of detail, but I will be here to answer any questions that you have about our therapeutic dockets or restorative justice. Generally, our therapeutic dockets are meant to address mental illness and substance use disorders. We have three behavioral health dockets, and we have a recovery court centered for substance use disorders. And then we also offer restorative justice, which is where if both parties agree, they can meet with a trained facilitator and talk about the harm that happened and come to an agreement between the two parties about how to resolve that harm and make it right.
Just a question about restorative justice and trying to also consider the wonderful statement you made. How often is restorative justice used and how is it used?
So it is not used as much as we would like. It takes both people to be willing to take that time to do it, and it is something that's pretty new, at least to the justice system in Virginia. So it's something that we've been really trying to build over the past few years. And we have sent a little over 20 cases to restorative justice, but it's open for consideration for everyone. It's just not as, it's not, the norm.
Hasn't gained traction yet.
Yes.
Yeah, hasn't gained traction yet.
Yes.
But Mr. Taylor?
What type of crimes are normally considered for the restorative justice?
We only have 4 criteria that would take your case out of consideration. One is if it involves the use of a firearm, so we do not send those to restorative justice. 2 is if it involves a sex crime. There are places in the country that have that as offered, but that is not something that we have trained people to do here. If it is domestic intimate partner violence, same thing. There are places across the country that do that, but we don't have anybody here to do that. And then if it involves like a relationship of power and control, so like if a child is the victim, or it was a teacher and a student or something like that, that's not really going to be able to be resolved in a restorative justice meeting. Did I miss any? I think those are the 4. Yeah. But other than that, we will consider restorative justice for any case where the parties want to do it. And
so of the 2 hypotheticals that you got, obviously Michael's would not be considered for restorative justice because he used a firearm. Even if the neighbor wanted to talk to Michael, that's not something that our office would facilitate. However, if Mr. Taylor was representing Jacob, and I went to Mr. Taylor as a criminal defense attorney and said, hey, would your client be willing to talk with Hannah? She wants to know why he picked her truck out. She was at a job site. There were 15 other trucks. Why her truck? What did he do with the truck while he had it for 2 or 3 days? Where's her equipment? Did he pawn it? What's going on? And if the defense attorney goes back to his client, and his client agrees, as Kelly said, then the Richmond Restorative Justice, which you can Google, Richmond Restorative Justice, is the organization that we created that is applying for its 501c3 status, but is up and running, has community members from every part of the city, and they are trained facilitators. They would first meet with each party separately, so they would meet with Hannah, talk to her, they would meet with Jacob, talk to him, and then they would all come together in a neutral, quiet, calm place and have a conversation about how to restore the community between Hannah and Jacob. And Hannah and Jacob, unlike the court or a lawyer, Hannah and Jacob would be the ones who are responsible for deciding what would be the appropriate disposition of what happened. And once they decided that, Hannah's like, I want a public, I want you to go on your podcast and publicly apologize for what you did, or I want you to write me a letter, or I want, at least $1,000 of restitution in the next 6 months. Or, I've learned from this conversation that you're a really good auto repair person or a mechanic, or somebody, so I want you to fix my truck. Once they decide on how they want it resolved, they agree, I think it's put in writing.
Yes.
Yes, it's put in writing. Their conversation is confidential, so if this agreement breaks down, I can't use it against the defendant, the offender. And once the agreement is in writing and Jacob completes his part and Hannah is satisfied, then we will either reduce or dismiss the charge. And that way, Hannah gets what she wants because she had the opportunity to have the conversation with the offender. And she also had the opportunity to let him know how it affected her. And that's one of the reasons that I'm so supportive of restorative justice, because a lot of times when you are a witness or victim to a criminal offense, you never get the chance to talk directly to the person who did it. Your lawyer talks, the judge talks, probation talks, pretrial talks. You never get to face the person and say, why did you do this to me? And hear from them. And that's what restorative justice provides.
Yeah.
So
I'll give you also the website, because it doesn't always come up when you Google it. I don't know why, it's a Google thing.
Okay.
But it's richmond-rj.org.
richmond-rj.org.
Yes, we have a question.
What happens when the restorative justice part breaks down?
So of the cases, well, yes, theoretically you do. Of the cases that we have sent through restorative justice, there were only 3 that were sent back, and it was because one of the parties changed their mind before the meeting happened. So all the cases where they actually met were successfully resolved. So we're confident enough in that process that we feel like it would be the unusual case that would have to come back for court. Typically, we do have an agreement, though, like a stipulation agreement to the facts of the case, so that we're not coming back to court to argue the facts. We might be coming back to argue the outcome if the restorative justice process doesn't work out.
All right, so for whatever reason the parties did not want to use restorative justice, we're now at trial. So everybody has seen a bazillion trials on TV, so everybody understands generally who's in a trial, what the judge is doing, what the attorneys are doing. As I've said, prosecutors, the Commonwealth Attorney's Office, is not allowed to talk directly to the person who is charged, to not use our power against them. We can only talk to their attorney, and their attorney has a duty to communicate with them what we have asked or said. The Commonwealth Attorney's Office has the extraordinary duty of providing discovery, that's the legal term, providing discovery to defense attorneys, whether they're public defenders or private criminal retained defense attorneys. We have to provide the body-worn camera from the police, any interviews that were recorded of the defendant, police report, any third-party videos, the neighbor's Ring camera, the interior camera from the 7-Eleven where the robbery was committed, any cell phone data. If we were able to get the offender's cell phone, we're going to basically download that cell phone and see if there is anything that we can use to show that what we are alleging the offender did is supported by what's in his cell phone. Like, here's a list of all his drug dealers and how much he's charging for, an ounce of cocaine and, this many pills. This is what fentanyl is on the street. Here's a picture of him flashing his gang signs with his guns and his drugs and his girlfriend and all of that. But we have to turn that all over to defense counsel so they know what the Commonwealth has. So no one, very, very infrequently is anyone surprised at trial. There usually is not a Perry Mason kind of like, and isn't it true? And everybody's shocked, right? Because all of this evidence has been produced. Now, sometimes witnesses who you have spoken with say something different when they're on the stand, and that happens on both sides. But generally, both sides know what the evidence is and which way the trial is going. Both sides, defense counsel and the Commonwealth Attorney's Office, are going to subpoena witnesses. If you get a subpoena, that is a legal document. You have to appear in court. It's not like, oh, this is not convenient for me, I'm not coming. You need to come to court. We could each have experts testify on behalf in support of our cases. Defense attorneys can ask the court to pay for an expert if they show the court that they need an expert in this type of, for this type of specific information regarding, depending on what the case is. Each side is going to create exhibits like this so that you can show the jury the picture, the video, the blood stain, the gun, the clothing that the defendant was wearing at the time versus the clothing he had on when he was arrested, the victim's injuries, all of that. So all of that's going to be created for trial. Sometimes before the trial, there will be motions. Motions to suppress the defendant's statement to the police, motion to suppress the traffic stop, motion to suppress this evidence or that evidence, motion to allow some evidence in. And that's a hearing. It's not a trial. It's a hearing where both sides argue their position, and then the judge makes a ruling. And you do all of that before trial because trial itself is so intense that you want to focus on that, right? You don't want to have a lot of kind of superfluous stuff going on. And then finally, obviously the defendant, the person who's accused, has to be competent and they have to be sane. And so a lot of times, unfortunately, because of untreated mental health issues or other reasons, the defendant, when they're arrested, may not be competent or may decompensate while they're at the jail and become incompetent, or to Michael's point, may have some mental health issue going on at the time of arrest. And so what his attorney would do is make a motion to the court before trial for Michael to be assessed and receive mental health treatment. Sometimes that can be done at the jail. Sometimes that can be done in the community. And sometimes, given the severity of either the charge or the mental history, it has to be done at Central State Hospital. So all of that will be done so that by the time we get to trial, the defendant is competent, he knows what he's being tried for, he's aware of who his attorney is, he knows what my role is, he knows what the role of the judge is, he knows what he's charged with. All of that has to happen before we even begin trial. Any questions? I think we did some of, well, no, we didn't do this one. So the law in Virginia has changed recently, and so now the defendant gets to choose whether or not he wants a judge or a jury. The Commonwealth really doesn't have a choice. So it all depends on the conversation, the confidential conversation that the defendant is having with his attorney. And his attorney will tell him, look, I know this judge hates property crimes. And if you go before this judge, he is going to do this, she is going to do this. Or I think I can win this motion before this judge. But if I lose, this is what you're looking at. And so the defendant is constantly having conversations with his attorney about how to present the defendant's case in the best way. And so the defendant gets to decide. The attorney, and correct me if I'm wrong, Alex, the attorney may recommend to his client, you know what, you should not try this to a jury. We should not. This should be a judge trial.
Sex cases.
Ah, okay.
We never recommend jury trial for sex cases because the jury will hammer the defendant if he's convicted for sex cases.
Okay.
A judge is can be far more conservative in that regard and not necessarily hammering the client because they've been around and they're not as impacted emotionally by the charge as a jury would be.
Okay. So that's why criminal defense attorneys are so useful and helpful in the system, because they can educate the defendant, who generally does not know how the system works and all the players in the system. You think you want a jury. You think you want 12 people from the community who don't know you because you think that you're right, or you think the evidence on the Commonwealth side is weak, or you think you've scared one of the witnesses and they're not going to come to testify you, and so the jury will be persuaded. And the defense attorney can be like, okay, so let me reel you into the real life. This is not TikTok, this is not social media, this is not your Instagram feed. This is what's really happening to you. And if you can tell me that you want a jury, and we'll do that, because ultimately you get to decide, because you know what? I ultimately will not be going in the back if the jury convicts you. So it's up to you. You want a jury? Fine. I'll tell the court you want a jury. I will not be going into the back. You will be taking it back if the jury convicts you. Yes, ma'am.
I'd like to ask our in-house attorney that you don't recommend a jury trial for sex cases because the jury would be more emotionally involved maybe or more. So the statement about a judge being more lenient, if you will, have you found your experience that could be gender-based? If it's a male judge versus a female judge.
Good question. Depends on the judge. Some judges are going to be more harsh than others. I know, for example, Judge Spencer.
Without naming judges.
Without naming judges, there's some judges that have a reputation of being very hard on sentencing. And so you avoid those judges like plague, and you would normally go with a jury in those, if you know your client's going to be found guilty.
And you know.
Exactly.
But her point is, does it make a difference if the judge is a woman or a man in your experience?
Only, like I said, it depends.
Okay, so it doesn't.
It depends on that man or on that woman.
Okay.
You can't make an over generalized statement of it.
Okay. Virginia's has a law about speedy trial, right? People can't be held in jail pre-trial for weeks and months and years and never come to trial. So once, if a defendant is held in jail, they have not been released on bond, they have to be tried within 5 months. If the defendant is out on bail, they have to be tried within 9 months. Now that 5-9 split can be extended because the defendant was getting mental health treatment, the attorney got sick, the attorney was pregnant, there was COVID and the court closed down. So things can continue it, but those continuances are in court, in public, they're not secret. And you can go to the clerk's office if you want to find out, why is this case that I read about in the paper or somebody told me about, why is this like still seeming to go on 6 or 9 or 12 months or 2 years later? You'll find out, it's not a secret. But those are the guardrails. Trials can last any amount of time. So if it's a quick misdemeanor trial in general district court, it could be 20 minutes. If it's a multiple co-defendant homicide case, it could last a week. So it just depends on the complexity of the case. The United States Constitution, one of the Bill of Rights, which one is it? 5, 4, 6, 6.
Confronted.
Yes, okay. So the 6th Amendment in your sheet, if you want to put a circle around that, the 6th Amendment guarantees defendants the right to be confronted by their accuser. So this is not going to be a Star Chamber Spanish Inquisition type of event where you're brought before the court and this panel is looking at you and they just say, well, we heard this and we've been told this and we believe this. The person who is charging you with the crime has to appear in court and look you in the face and say, that's the person who shot me. That's the person who I saw hitting my car and causing this damage. That's the person who I know well who's on this video showing XYZ. So that's the confrontation clause. Witnesses are sequestered during trial. Sequestered just means kept separate. And obviously you don't want witnesses to hear or talk about what they recall or what they think or what they know and taint each other. So witnesses are kept separate during trial. And then finally, if you are convicted, you have the right to appeal your conviction. So if you are convicted of a misdemeanor in general district court, you can appeal, and juvenile.
Yes,
yeah?
yes.
If you are convicted of a misdemeanor in general district court, whether adult general district court or juvenile and domestic relations court, JDR, you can appeal to circuit court. And if you are convicted in circuit court, you can appeal to the Court of Appeals. And if they do not reverse your conviction, if they affirm your conviction, in limited cases, you can appeal to the Supreme Court of Virginia, and their ruling is fine.
Well, unless you have
unless it's a constitutional
and then you
issue.
can appeal
Yeah.
to the United States Supreme Court.
Yes.
From my understanding, trials are open to the public.
Yes, unless it's juvenile court.
That was my question.
Yes, for juveniles under 14, and then if they're 14 or over, if they're charged with a misdemeanor, those are all private. 14 or over, if they're charged with a felony, are open to the public unless the judge makes a determination that they should not be. And so sometimes with cases involving kids on either side, the judges can decide that it's too influential for the public to be in there, and if it's not in the interest of justice, they can close the courtroom. But they're, the public has that First Amendment right to be present in most cases unless there's a limited exception.
Anybody else? Okay. So we've had our trial, we've had our arraignment, we've talked about bond, we've talked about the role of prosecutors and defense attorneys, we've talked about proof beyond a reasonable doubt, which is what has to be proven by the Commonwealth and by the state. The person has been, we'll get to verdict. So now we're talking about verdict and sentencing. So we've had the trial, we've made closing arguments. If the trial is a bench trial, i.e. just a trial to the judge will usually rule immediately. They've heard all the evidence, they've acted like the jury, right? So they'll rule immediately. If it's a jury, the jury will deliberate immediately after all the evidence is presented. And so a lot of times when the jury is selected at the beginning of what defense counsel and the prosecutor know will be a multi-day trial, one of the questions we will ask jurors, potential jurors, is, do you have some reason that you can't focus on the evidence that's presented for the next 3 days? Well, I can't be here because I have, cruise tickets, or I have to give this huge thing at work, or I've got surgery scheduled. All of those things will be taken into account because immediately after the trial is over, you're going to be sequestered as the jury and you're going to have to deliberate and come up with a verdict. The jury can find the defendant guilty as charged. So they could find Michael guilty of malicious wounding for the shooting.
Maybe use of a firearm.
They could find him guilty of a lesser offense. They could find him guilty of maybe just
unlawful wounding or assault and battery.
They could find him not guilty. Or they could not reach a decision, in which case it's a mistrial, it's a hung jury. If the jury finds him guilty as charged, that verdict must be unanimous. Also guilty of a lesser offense, also not guilty. The verdict must be unanimous. And in Virginia, that means all 12 people. in, I think, Louisiana until recently, it was 11
It's
to
like 10.
1 or
Oh,
10.
yeah,
well,
something
yeah.
like that.
So the person would still be convicted even if one person didn't believe that they were guilty. But in Virginia, that is not the case. So the verdict has to be unanimous. And once again, I already, just as the defendant can choose whether or not it's a judge or jury trial, the defendant, once again, can choose whether he wants to be sentenced now that he's been found guilty by the judge or by the jury. The jury would get in writing all of the law that applies to that case before they make their decision about guilt. And then if they decide that Michael is guilty of unlawful wounding, for instance, then they would get in writing what the penalty is, and they would be able to write a number within that penalty range as to what their verdict is. Once the jury has concluded their work, Michael's been convicted, Jacob's been convicted, either side can ask for a pre-sentence report. And that is a report that's conducted by probation and parole. And they would do essentially a social history of the defendant: parents, relatives, education, employment, prior record, mental health issues, drug issues, all of that. And that pre-sentence report would be given to both sides and to the court to review before we actually went to sentencing. So even if you have the trial and then you have the jury verdict and then you have the jury sentencing, you can still ask for a pre-sentence report, and the defendant usually will be held while the pre-sentence report is done, and then come back for the actual sentencing hearing. The state of Virginia has sentencing guidelines. So in the past, prior to 1990s, maybe, when we first started?
I want to say it's like 1995.
Yeah, okay,
something like
1995. Okay, so prior to 1995, judges basically just did whatever they wanted to. They didn't have to explain their decision as to what the sentence should be, just like juries don't have to explain. And so sometimes when you read about trials in the paper, you're like, how did the jury decide on that? Juries don't have to explain anything. They don't have to explain it to me. They don't have to explain it to the court. They don't have to explain it to defense counsel. Once a jury says you're not guilty, I will spend, weeks going, how did they find him not guilty? Or I'm sure Alex will be like, how did they find my client guilty? They don't have to explain. So judges didn't have to do that. The General Assembly decided that they wanted to set up a guideline sheet, a matrix. And so now probation and parole and our office run guidelines so that there is a range of penalties that the court can consider. So this is the statutory maximum. Grand larceny is 20 years. But the guidelines may give you a range based on your defendant's history of 2 years to 6 years. And that is what the court will look at, not automatically the maximum. Victims can either write an impact statement. Sometimes victims are so traumatized that they don't want to have to appear in court again and face the defendant again and say what happened to them again. So they will write an impact statement, and that'll be considered by the court. Or some victims are like, oh yeah, I want to look them right dead in the eye again and tell them exactly how I feel. Then they can come to court during the sentencing and talk on the stand, speak on the stand. And then of course the defendant can say his piece. And so after the Commonwealth has presented all of its evidence at sentencing, once the defendant's attorney has presented all of his evidence at sentencing, the last thing the judge will say is, Mr. Jacob, do you have anything you want to say to the court? And he stands up and he can decide whether he wants to say something or not. Okay. I'm being reminded here gently, it's time to speed on.
I think we already talked about incarceration and fines,
okay.
So we can skip that one.
Okay. So if you have been, so we'll do expungement, yeah. So if you have been If you have been charged with a crime, but you were not convicted because the Commonwealth now processed the charge or dismissed the charge, you can get the charge expunged. And we just had a great expungement clinic yesterday.
Yes.
With how many people came through?
Well, so about 6, I think, made it into court yesterday to be filed, but the clinic was actually here. And we had a lot of people show up close to the end of the day. And so they didn't have time to file yesterday, but we're gonna get those done this week, so.
So it's a petition for expungement. It goes to the court. It's for charges that did not result in a conviction. Right now, the law in Virginia is if you're charged, if you've been convicted, if you've been found guilty, it can't be expunged. Sometimes people think, oh, well, it happened when I was a juvenile. Once I turned 21 or 25 or 30, it kind of fell off my record. No, not in Virginia. Well, it's been so many years since it happened. Doesn't matter. If it was a felony, I mean, you were convicted of either a misdemeanor or a felony, right now, it can't be expunged. However, in 2016, next year, the General Assembly has declared that there will be a new law for sealing certain convictions. So a misdemeanor can be sealed 7 years after the date of office, after the conviction. If you don't get any further charges in 7 years, the misdemeanor can be sealed. Felonies following 10 years of no arrest, the felony can be sealed. So that's coming up next year. We talked about the expungement clinic. My office obviously wants to support people having the appropriate charges expunged if there were not convictions. And so generally it costs $100 to file the petition in the court, and we are waiving that fee, so it's free. And then charges and convictions typically remain on your record if they're not expunged or sealed. So, and anybody can get a record. If you want to know, just like, I wonder if somehow something that I know happened years or decades ago, you just go down to the Virginia State Police Department and they run your fingerprints, and I don't know how much it costs, and you can have your criminal record.
Yes, and I brought our fact sheets on expungement. I'll put them at the table in the back with the goodie bags.
All right, and I will also ask Kelly to pass those out to you or have them in the back. So this concludes your first day of criminal law. But I did want to let you all know that the office really is interested in people knowing as much about the law as possible, right? Mind is a terrible thing to waste, all of that. So the next upcoming event is a public forum that anyone can come to regarding the Family Justice Center. So I am working with Rupa Murthy, who is the CEO of the YWCA for Richmond, and in conjunction with Mayor Avula and lots of stakeholders, and we want to create a freestanding Family Justice Center for victims of intimate partner violence and domestic violence. So it's a one-stop shop. So they can come to one place and get the protective order, get the services for the kids, deal with the homeless situation they're now in because they left their abuser, all of that, so that they don't have to figure out the bus schedule or the work schedule. So if you are interested in that and you want to come and be in on the ground floor and talk with the people who are going to set this up and make sure that the things the community wants its members to have when they're in that traumatized place exists, please come. It's going to be at the Convention Center, Monday, April 14th, 8:30 to 11. So come right before work or come as an early lunch. And then obviously we'll continue to have information about this as we stand it up. But that is the next exciting thing happening in Richmond. Any questions? All right, thank you all. Class dismissed.